You have noticed today, our first complaint was the difficulties we face in accessing the court premises. Today, I was harassed as I was entering the court. There was a police officer by the name of Asio. She wanted me to alight from the vehicle outside the gate. And I refused, telling her that all the times I have come here, my vehicle is allowed to drop me on the staircase next to the court where I'm going. So she allowed the car to enter the court premises, and next to the door, she now came again and told me, "You are now inside the court premises, get out." I told her no, I wouldn't get out. I want to be dropped where I'm usually dropped, next to the court, not at the door of the court premises. And she just from nowhere said, "Why are you being difficult? This is not a Kenyan matter. I have not come to Uganda or to the court to have words thrown at me and disrespect shown by a police officer or anybody else for that matter. When I come to court, I come as an officer of the court, duly licensed under the laws of Uganda. And that is why I raised the matter with the court. The court has a duty to protect all those who come to the court, both those who come to listen, the accused persons, or people like us who are officers of the court. Because how else will an accused person be able to have a lawyer of choice if when we come to court we are subject of harassment? The court has promised to deal with the matter, and we'll be approaching the judge in chambers as he asked us to do. It's just that we had to first see our clients in the court cells before they were taken to Ruzira prison. Now, on what has transpired pertaining to the case, today was what we call case conferencing or scheduling for the court to say when the hearing will start and how long it will take. All those things are pertaining to hearing. We told the court we couldn't go there because we couldn't start with the case conferencing because the prosecution only did a partial disclosure. They've given us statements of 4 witnesses and transcripts from audios and videos that we are yet to see. The Constitution of Uganda is very clear that there should never be trial by ambush. An accused person and their lawyers must have in advance the evidence against them, all witness statements. If there is a transcript, you give the audio first, long before the transcript. How do we know that the transcript is the same as the audio or that it is authentic? We also have a duty in these days of AI to know whether the transcript is actually a real transcript or a fraudulent one. So on that basis, the court has adjourned the case to the 24th of March, to the 12th of March, and the prosecution has been ordered to give us full disclosure on or before the 3rd of March. Now, the prosecution has been claiming, we've seen it and we've seen government officials, including officials from State House, especially during the campaign period, claiming that it is the defense lawyers who are delaying the case. We want Ugandans and the world to know that up to now, the prosecution has not done full disclosure. Under Ugandan law, the case cannot commence without full disclosure. So the delay in starting Dr.Besigye and Obed Lutare's case is not on the defense, it is on the prosecution. We also worry about Dr. Besigye's health. Anybody can see for himself that he looks frail. He's getting sick so often in prison. We do not know what has changed in that environment, but it's certainly compromising his health. So I was telling the court, I was pointing out to the court that the health of Dr. Besigye is among the things he must consider. Because at the end of the day, the court will want to know whether he is in a position to go on with the trial as he is. I think that is all that has gone on today. Karua Senior Counsel, leading the defense alongside my very able colleagues, Arias Lukwago is right here. Ernest Galibara, Isaac Kwagala, Simon is right here, Isubu, and Hanifa Namakula. For the state, Assistant DPP Thomas Jatiko. I wish to first lay a complaint to the court before even asking what is the issue for the day. As we were coming in, a certain police lady by the name of Asio was hostile and rude to me, telling me that this is not a Kenyan matter. Asio at the gate, and I even complained later to her senior, Mr. Chebet, and informed them I will make a report to the court. We do not come here to be disrespected. We come here to do our duty as officers of the court. And this is not the first time we are making a complaint of undue hostility by officers manning the gate, but today it's specific on the police officer, a lady by the name of Asio. And it is the duty of the court to protect me and other court officers from undue harassment. We are here to do our duty under the Constitution and the laws of Uganda. And I'm duly licensed to practice here for this case. So we are urging the court to discharge its duty of ensuring that we come in here without let or hindrance, and that the officers know their boundaries when manning the court gates.
At the gate?
I think she is at the gate, yeah. But as I've said, I did also report to her superior, Mr. Chebet, who was not at the gate at that time. Chebet, yeah. I'll leave the matter to the court. Having said that, I left the court before the last orders, but I'm told we are here for case conferencing and direction on the hearing. But from the defense, we are yet to receive all the documents and evidence relating to this case. We have a huge file that has 4 witness statements and tens of copies of transcripts.
Otherwise, you are saying they have disclosed.
No, I am saying we have 10 witness statements handwritten, not 10, 4 from the prosecution, and tens of pages, meaning 20, 30, 50 of transcript from audios or videos we are yet to receive copies of. So we wouldn't know whether those, from whom those transcripts are. We wouldn't know the voices in those transcripts. I've had a conversation with Mr. Jatiko. I think he can brief the court or confirm to the court that indeed they are yet to fully disclose the case our clients are facing. And as such, we feel we should not be going into conferencing when our clients have not been given adequate time and facility, because that means disclosure, time and facility for the case.
And also, the record, Thomas, assistant deputy. I don't think it's true the prosecution has made partial disclosure to the defense, and as rightly put by my young senior sister, he gave the defense transcribed material of audios. We gave the prosecution some the defense transcribed material from audios and videos together with witness statements. I noticed from the moment that we received the transcribed material and the original gadgets from which these transcribed form, we have been in the process of having this material transferred to gadgets, various gadgets, which can enable us ably disclose to them. Some of these include flash disks. And my Lord, today I believe there are 18 lawyers here, and so we are really trying to make sure we have copies for all of them. And this will be accompanied by the forensic report. I know the prosecution is confident that if given a date by Tuesday next week, we would have served the defense. We would have done it right over the weekend. I want to be on the safe side. We pray for make this disclosure by the Tuesday of next week. That is third. Third of March. That is the position of the president.
It's not that clear as to the prayer they are making. The prayer they are making is not clear. We have not had any application for an adjournment of the matter. My learned friend Mr. Jatiko simply indicated that they would be ready to make full disclosure by 3rd, leaving court in suspense as what to be done with the schedule of today, which is conferencing. If, my Lord, I understand him to be making an application for adjournment to 3rd or thereafter, we strongly object to that, my Lord.
Can we make a clarification on the people? As what we saying today, before you go for adjournment for this week, what are we taking today? Let me call it preliminary hearing that scheduled by the council. Let us before we go for adjournment.
Scheduling among us disclosure. And I was polite enough to be responding to the immediate query.
Yes, that is okay.
My Lord, that is
I want to put them against the wall.
be praying. Not done.
Okay.
And not bad.
My Lord,
Let us put this narrow down.
When
Most of you are saying there is part of disclosure, which has been done. There is it, most of you here.
yes, my Lord.
So,
Partially disclosed. And my Lord, the prosecution did not wait with scheduling today, because that is when we would be agreeing on disclosure. We started this knowing we would have time within which we would need to transfer this material from the gadget to a disclosable mode for all the defense counsel that are present here. And so we did not wait for today to start the schedule.
So you are saying you disclose it partially before the case?
Yes.
It was supposed to be done.
Yes, my Lord.
And then you say full disclosure by next week, maybe.
They shall have given their disclosure.
this right function. Yes, my Lord, we strongly oppose the application made by Mr. Jetiko. We oppose to that. I heard he's seeking for an adjournment. It would appear, my Lord.
He says which is not in dispute that he partially made a disclosure and he wants his day for full disclosure. Let us address that. So you don't want disclosure by next week or?
Well, my Lord, there is no reason, justifiable reason advanced as why they never abided by the court order as to the disclosure.
I think what if I got him correctly, he said we are supposed to come here for preliminary hearing, including disclosure. I think that was the position last time when we
No, my Lord, disclosure ought to have been done much earlier, before today's session, before today's...
The disclosure partially was late, but now they are saying disclosure next week. So you are proposing that if I put it down.
My Lord, if you could visit the record, the proceedings of 30th December.
What I'm saying is,
Yes. Yes?
I want to start with you and Counsel Martha. Disclosure was partially done. It's not in
No, my Lord, wanted to address your mind to the order of this honorable court.
the order. Let us go to disclosure.
Yeah, the order regarding disclosure, my Lord.
Was partially done.
My Lord, before
Have not been disclosed.
we come to partial disclosure, we wanted to...
Counsel Martha. The issue here is disclosure.
Yes, my Lord. And there is a court order to that effect. And there is a court order to...
Let me know your response of disclosing fully if I go to they disclose partially, which is evidence. But now we are saying they are paying at judgment to fully disclose of life. Yes, we decided. So let me get you a response.
Okay. Our contention, my lord, is that partial disclosure was done in violation of a court order. Because, my lord, on record, specifically the proceedings of 30th December.
You are saying they violated by disclosing before the date?
No, by making partial disclosure. Full disclosure ought to have been done by 21st January 2026, as per the court order on record of 30th December 2025. There was a court order, a directive that they should make full disclosure by 21st January. The reason as to why that was not complied with is not satisfactory. If I listened well to Mr. Jatiko here, that they are still doing, they have not completed the transcription. That they were, but you are talking of gadgets, the gadgets containing that particular evidence which they wanted to transcribe being somewhere, kept somewhere. That's how I, that's what I had. That's what I had. Otherwise, my lord, the transcription should have been accompanied by the flash disks he's talking about, the video recordings, the audio recordings should have come with the transcribed record, which is not the case. Secondly, my lord, when you look at this file here, which they served on us, it indicates volume 1. So we have no idea as to how many volumes they are processing. We have no idea. Volume 1, is there volume 2, volume 3, volume 4, volume 5? The order was specific. By 21st January, we should be in possession of all what they are talking about. Whether they are several volumes, they should be with us as of 21st January. So court orders are not made in vain, my lord. That very day, 21st when we are here, my lord, the last time we appeared here on 21st, there are orders that were given to serve us within specific timelines, and they never complied. My lord, if I may revisit the proceedings of the day, we indicated to court on that day, 21st, that the TIA provides for a notice of 14 days. 14 days before one takes a plea. And in the ruling of court, my lord, in the wisdom of court, that notice with all due respect to court was fabulous in the wisdom of court. So court went ahead to direct that everything be done on that day 21st. And disclosure be made so that we come here for conferencing today. Now we are getting the shock of our life that they are not ready to make a full disclosure. That shouldn't be condoned by court. My Lord, while we are raising this matter, I want to conclude. While we are raising this matter, we have been unfairly accused as the prosecution, the defense lawyers, for delaying the hearing of this matter. We have been unfairly attacked by the state that we are deliberately delaying the proceedings of this matter. Now here we are. That is one of the reasons why we take exception to the conduct of the state in this particular matter by making partial disclosure. The second reason is in regards to the health of our clients, particularly A1. So any delay occasioned by inadvertence on the part of the prosecution aggravates the matter. So A1 is not doing well health-wise, and he has not been granted bail. So, my Lord, we pray that this court takes cognizance of that conduct first and foremost, and then one way or the other issues some directives to the prosecution here in regards to that particular conduct, where they defy court orders, make a partial disclosure as opposed to full disclosure in total disregard of the court order that was made on 30th December, going beyond the deadline of 21st January.
For the record, Judge Kopromas, I know this court has a record of the scenarios that my land friend pointed to, and I also do have a record. Your mind is not be the court record, but why would this matter came to court on the 3rd of December? And my lord, 30th December 2025. And my lord, among the things that the court had said, assessors shall be appointed with detail at the time of hearing, and among others, the court directed that the matter is fixed for scheduling on the 21st of January 2025 at 11 a.m. Matter is fixed for scheduling for the 21st of January 2025 at 11 a.m. And there are no directives as to disclosure from this court. However, my lord, the prosecution insisted that it will make partial disclosure. The prosecution said it will make partial disclosure because all these matters are supposed to come for scheduling on 21st. In fact, we did make this partial disclosure as confirmed by the defense. My lord, on 21st of January 2026. The accused person never appeared in court. On the 21st of January, and my lord, we were in court. And they say the accused person or person is unwell.
Yes, we were here.
And my lord,
Posted. No.
my lord,
That's why I had to
we are also calls for the presence of the accused persons really in these matters in court. And we were all in court with counsel, my land senior colleague report.
I was here.
We felt their plight and the plight of the accused person. And my lord, the matter was adjourned. Then, and we have humbly told this court that the materials that my land sister, she has talked of tones, my lord, that information must be transferred in a form that we can give them. Today there are about 18 lawyers here. It's not a piece of cake, my lord, that we are sharing out. We must maintain integrity of this evidence that is coming before. And my lord, to say that we're in violation of the court order, my lord, we believe is misleading this court. And we retaliate that the prosecution shall, by the 3rd of March 2026, give disclosure to the defense in the form that they can be able to look at and be able to advise themselves about the case. I don't believe this is the position of this court.
That's what it is. That's what they were saying.
This is not a record. I am not wrong. So humbly remind.
That's the whole point.
When you simply talk about the time of this brother, instead you are paying, you did also ask for when you are ready to do the scheduling, because we are here for scheduling.
For scheduling.
You disclose on Tuesday. Tell us when you will, or give us an indication so that we also tell you when we will be ready for scheduling. Because for the record, Your Lordship, we want to emphasize that and clarify that it's impossible to schedule without full disclosure. The reason the state must shoulder the burden and accept that they are the reason why we have not scheduled and why we have not proceeded to trial is because they have hitherto failed to fully disclose. Had they disclosed, we wouldn't be having this discussion. Today, we probably have scheduled. So we need full disclosure in a time sufficient allow us to peruse it, and then prepare for schedule, and then at schedule, lay out the roadmap of trial. The state should stop delaying, procrastinating, diary, and then coming here and later in public domain, lambasting the defense team for their own claims of a snail test and lackadaisical approach towards the prosecution. We reject it and we think it should join us in treating this prosecutorial conduct is the content of the class. The issues of sickness are red herrings and are diversionary. They have nothing to do with the disclosure. Have the defense, the prosecution failed to disclose because the clients were sick. So they shouldn't take us there. Let us focus on their duty to give us every document and written statement in their position so that we read it we come here and schedule, then we go for trial. So can we hear from the prosecution when they are ready for scheduling?
No, my lord, just to clarify on this, because we wanted the record to be consistent. Before we look at the next course of action, the record of 30th, because we have a position, 30th of December, we have a position that there was a directive that disclosure should be done by 21st January, and that scheduling be done on 21st January. Mr. Jatiko is saying, no, there was no directive to that effect. This must be sorted, my lord, before we proceed. Was there a court order to that effect that there must be full disclosure by 21st January? Given, handed down by this honorable court on 30th of December. We insisted that is the position on record, my lord. And they never complied. And while we are justified in our submission, my lord, in our line of contention, my lord, it's very clear. And actually, it's logical. There is no way we would come for scheduling on 21st January before full disclosure is done. It is simply a matter of logic that we are supposed to come here for scheduling on 21st January after full disclosure is done. Now, Mr. Jatiko is insisting that the position of the prosecution is that by 21st January there will be partial disclosure. Whether A1 was indisposed or not on that day, it's immaterial. There was a standing order of this honorable court. And this is the matter we are seeking to be resolved first before we focus on anything subsequent to that. We do so, my lord.